Hi guys, it's Kathy. I hope you're doing well. We're missing our favorite judge. We really are. I am very much. So, we've been doing these trials lately that are just so frustrating. So, let's go on a different type of roller coaster. This is a slow burn. I mean, it starts out okay. It does. It starts out okay. But then it ends great. Great ending. Once he gets to get everything off his chest, then realize he might be wrong. But, does he really realize he's wrong? No. We're going to go to the courtroom that looks like hell. Like, if you're in hell, this is what a court would look like, I think. It's Indiana. But I love this judge. I do. I love all the judges. If I don't love the judge, I don't get videos of the judge. So all the judges that I get, I love. But usually the judges are the star of the show. And this judge is this time because we're just so used to judges. The last week or so, we have judges that cannot get control of the courtroom. The lawyers are just, and the defendants are just all over the place. And this judge has tight control of this courtroom. Do not worry. And there are no binders, and there's no potty training. I mean, you can potty train. Don't stop potty training during this video. Continue to potty train. But there will be no potty training in this video. Maybe. Or towels. Maybe. Let's go. Indiana.
This is State of Indiana versus Robert Frost, cause numbers 20D012204 F6502, 20D012207 F6914, 20D012304 F6476, 20D012304 F6489, 20D012309 CM1725, 20D012405 F6540, and 20D012501 F664. Mr. Frost, please raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide this court will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes.
Thank you. Please tell me your full name.
Robert Stanley Frost.
Thank you. The court shows that the
His name is Robert Frost. I love that. I love it.
defendant appears by video from the Elkhart County Correctional Facility as a self-represented litigant. The state of Indiana appears by DPAs Rich and Leong. I showed that we are primarily set.
I'm going to try to just get rid of that whistle real quick. Oh, it's already real low. I don't know if I can, guys. I think we're stuck with the whistle.
Today for final pretrial conferences for all of the cases with the exception of F664. The full cause number is 20D012501 F664. Mr. Frost, it's the court's understanding that in that cause of action, you were recently served with a warrant for a new case that was filed against you by the state of Indiana. Did that in fact happen?
This morning, yes, it did, 9 o'clock.
Mr. Frost, we will come back to that case in just a few moments. I will conduct an initial hearing with you on that case before we conclude these proceedings. So, Mr. Frost, you are set for trial on February 11th at 8:30 a.m., which is coming up. Do you understand that that is your trial date?
For my appeal case, yes.
When you say your appeal case, I show that your first setting is cause number 20D012204 F6502. And I believe that that is one of the cases that was reversed and remanded and sent back to the court. Are we saying the same thing?
Yeah, that and 0914. That's the jury trial, yes.
Mr. Frost, we can only proceed on one of those cases. So the first one would be 20D012204 F6502. So if that case proceeds on that day, we'll have to come back on a different day and try the other case.
Oh, I didn't know that. Okay, so it's two different trials then.
It is. The state of Indiana has not moved to join these charges, and I don't know if they have a legal basis for doing so. So because of that, they would be two separate trials.
All right.
Your Honor, I think I can speak to that as well. Mr. Frost had submitted a letter to the court asking essentially for joinder. I was going to file a joinder motion last week, but I held off on that because I wasn't sure what the court would do with Mr. Frost's request. I note that he has requested a bench trial in those cases as well. So does the court want to take that out? I mean, the state is perfectly fine because they're so related in time, place, manner, and witnesses.
All of them.
Those invasion of privacy cases
All the
involve
cases.
the same people.
Everywhere.
Can I interrupt, please? This was started last week. Can you hear me, Your Honor?
I can hear you, Mr. Frost, but hang on, Mr. Frost, hang on a sec. You had filed some correspondence with the court, and I wasn't sure exactly what you were asking for. The first letter that I think that Mr. Leong had referred to is a letter that I show that you dated on December 23rd. And then there's another letter that I show that you have dated on, wait, sorry, bear with me. I'm just trying to find the date on here. I'm not seeing it, but it's the two most recent letters that you have filed with the court. Can you just kind of summarize what you're asking the court to do in those letters?
Let me jump back to the appeal that was granted to me. Those two cases, that's when we first met so long ago, Ms. Osterday. Now, all these other cases...
Miss Osterday is the judge. That's when he met the judge.
Piled on. And those have nothing to do with a jury trial.
Indiana.
With an appeal case. That's all I want to have is the appeal trial that was granted me of 502 and 914. All those other cases are just invasions of privacies, whatever. That has nothing to do with the jury.
Okay, so Mr. Frost, I'm not sure that I completely agree with you on that, but let's make sure that I understand maybe some of the things that we do agree on. So I think what I'm hearing from you, sir, is that you agree to join the two cases that went up to the Indiana Court of Appeals and where the convictions were reversed and the cases were remanded back to the court. So those would be cause numbers 20D012204 F6502 and 20D012207 F6914. Is that what I'm hearing from you?
Yes, ma'am.
Okay, and does the state agree to the joinder of those two causes of action?
Yes, Your Honor.
Okay, so Mr. Frost, the court will grant that request to join those two causes of action. So
I'm sorry, Jen.
All of those allegations will be put forth before the jury on February 11th. Do you understand that?
Those two cases, not all those other cases, correct?
That is correct.
Yes, so that's just the appeal. Yes, that's what I want. Thank
Okay.
you. And I'm glad that they're joined together.
Okay, so Mr. Frost, I understand that the allegations in the other causes of action, with the exception of one of the causes of action, relate to an allegation that you violated an order of protection. However, there's a separate case that is unrelated to really any of those cases, and I believe it was something that was alleged to have happened at the Faith Mission. So that would be a separate issue that has dissimilar facts. Do you agree?
Yes, that's a whole different matter.
Okay. I think we're on the same page as far as that is concerned.
Thank you.
Okay, so Mr. Frost, we have had a discussion about you wanting to represent yourself at trial. The court had previously appointed the appearance of the public defender's office. Mr. Altenhoff was assigned to your cases. We were very close to a resolution regarding most of those cases. And prior to sentencing, the state of Indiana had filed the allegations that arose from the Faith Mission that we just talked about. Mr. Frost, I also recognize the fact that when your cases were in Superior Court 5, just having reviewed some of the appellate history, and it's been a while since I've reviewed those cases, my understanding also is that you had the public defender's office involved and then maybe not involved. And so just maybe decisions on various points of time when you wanted the public defender's office involved. Mr. Frost, are you sure you do not want an attorney representing you at trial?
No, I didn't have one the last time. I had dismissed her. She didn't follow my instructions. The court ordered the public defender's office to be present in the court in case I should change my mind at the last minute, and the whole trial was in motion, and they didn't want to waste their time, and so they had her stand present. She had nothing to do with the trial, made no decisions, had no conference with me. The only thing she gave me was a pen when I couldn't reach my own pen because I was chained.
Okay, Mr. Frost, I know that different judges have different practices on how they handle standby counsel. It is this court's practice that I do not appoint standby counsel. You understand that you do not have standby counsel?
Yes, and I'm fine with that. Thank you.
Mr. Frost, and just to be clear, let's take it one step further. Let's just imagine that we're in the middle of trial and maybe you come to the realization that it was not a good idea to proceed without the assistance of an attorney, and you decide that you want to stop and have an attorney. Do you understand that that is too far and that I will not grant that request?
I understand. Yes, I do.
So, Mr. Frost, either the attorney is in or they are out. And I think I'm hearing you say definitively that they are out. You do not want them involved in your cases at all. Is that what I'm hearing from you?
That's correct, ma'am.
So, Mr. Frost, I want to again express to you my concern about proceeding without the benefit of an attorney representing you. I think that it puts you certainly at a disadvantage as you are not a trained attorney. I'm not saying that you lack intelligence. It's clear that you are an intelligent person. It's clear that you at least have some familiarity with the legal process as you have found some success with the Court of Appeals.
So he went pro se on 2 cases to the Court of Appeals and won. And now they have to redo them, and that's where they're at with just those 2 cases. And then there's this one weird case where he was at the mission and he got into a spot of bother. And then there's a whole bunch of other cases of him not stalking anything, some kind of protection order that he broke. But it's definitely not stalking, as you will hear.
However,
Invasion of privacy. That's what it is.
I would not assume that just because you've had that previous success that you will continue to have that success. Do you understand
Walter, I missed you during OJ.
that?
Yes, but I'm fine, ma'am. Thank you.
And Mr. Frost, just bear with me. I have to make this record with you, okay?
Sure.
Mr. Frost, do you understand that you are going to be held to the same standard as an attorney as we go forward before the jury?
Yes.
And Mr. Frost, the one conclusion that I like to have with people who choose to represent themselves is I like to say that you may have the law on your side, you may have the facts on your side, but if you don't know how to appropriately argue that law or present your facts, do you understand that you could still lose because you are not a trained attorney?
Yes, I understand that.
And do you understand that by representing yourself, that you may also be waiving your right to remain silent, which is a constitutional protection that you enjoy?
Yes. And I plan on taking the stand in my own defense in the jury trial.
All right. Mr. Leong, is there anything else that the state would like addressed?
I do want to let the court know I will file that joinder motion tomorrow then. I had held off because I wasn't sure what exactly Mr. Frost's position was going to be based on his letters, but I will be moving to join the other invasion of privacy cases, not the intimidation involving the faith mission, but I'll be moving to join the additional charges. Also, I think he may need an initial hearing on the new charge.
He does.
You're talking about joining them together in a what? Not for the trial that I'm going to with the jury. This is something different.
Mr. Frost, I think that you're in agreement with what Mr. Leong is saying. We're just talking about those 2.
When he closes his eyes and speaks like that, I just feel like he's like a medium and he's channeling. He's channeling the other side. You're not talking about these The first cases, right? You're talking about something different, something that starts with a letter J, right? Hi, Adam.
Two cases that went up to the Court of Appeals, joining those two cases so that all of those issues can be heard in one trial. That's all he's saying.
No, Your Honor. Mr. Frost is correct. I'm talking about additionally joining the other invasions of privacy.
Okay, Mr. Frost, you caught that correctly. I did not. So, okay.
But I'm sorry, but there's felonies and there's misdemeanors. And with felonies, I have the right to choose a jury's trial. I believe I wrote you a letter with the request on how I thought I'd like to proceed it. And some of it joined and some of it not.
Well, Mr. Frost, you do have the right to have a trial by jury in a misdemeanor case. And the only way that the court can go forward without doing it as a jury trial is there has to be a knowing and voluntary waiver. So at this point in time, there is no motion for joinder. I'm hearing the state of Indiana is going to file that tomorrow. If they in fact follow through to join all of your pending causes of action, then that will need another hearing prior to the trial on February 11th. So, Mr. Frost, assuming that we are going to have that hearing in the near future, when I hear arguments on that motion for joinder, I'm going to want authority under Indiana law as far as why I should not grant the state's motion for joinder. So I'm giving you the heads up so that you can prepare that and be prepared to make a legal argument, assuming that we're going to have that hearing. Okay?
Crystal clear, Judge.
The joinders could be felony charges and misdemeanors put together.
That is correct.
Okay, I'll be prepared. Thank you.
So at this point in time, I will confirm the jury trial with respect to all of the causes of action, with the exception of the newest case that we will do an initial hearing on in just a few moments. And that jury trial is on February 11, 2025 at 8:30 a.m. Mr. Frost, do you acknowledge or understand that your trial is set for that day?
Yes, I do.
Mr. Frost, you will be transported to the courthouse for that trial. Do you understand that if you refuse to cooperate with the transportation process, or if there's some other reason that you are voluntarily absent, that we will go forward without you?
Yeah, I won't have any problem with it. I have a sport coat here at the jail I can wear.
And usually the public defender's office does assist to make sure that people have the appropriate clothing, whether they're involved or not, which is a service that the court certainly appreciates. So, Mr. Frost,
good.
It sounds like that's not going to be an issue.
Well, okay.
And again, we'll take up the motion for joinder if and when it's filed. So let's turn now to cause number 20D012501F664. Mr. Frost, as you were made aware this morning, the state of Indiana has filed a new case against you, and we are going to do your initial hearing.
Were you in jail? You were in jail, weren't you? I know you were in jail.
All right.
The first thing that I would like to do is go through an advisement of rights with you. Mr. Frost, you have the right to have an attorney appointed to represent you. I'm still going to have that discussion with you, so bear with me in just a few moments. Mr. Frost, you have the right to have the state of Indiana prove beyond a reasonable doubt that you committed the offense charged. You have the right to have a trial by jury, also in that cause of action. You have the right to appeal any decision that is reached by this court to the Indiana Court of Appeals or the Indiana Supreme Court. However, if you plead guilty, there may be a limited right of appeal. You have the right to confront and cross-examine any witnesses that the state of Indiana may call to prove the case against you. You also have the subpoena power of the court, which means that you can require that witnesses appear at any evidentiary hearing and testify on your behalf, and the exercise of that right does not cost you anything. You have the right to remain silent, and if you choose to waive that right, anything that you do say can be used against you. Mr. Frost, do you understand the rights that I just explained to you?
Yes, I do.
Mr. Frost, were you provided with a copy of the charging information that was filed in this case?
No. All I did, the correctional officer approached me this morning, read it to me, and I said, well, can I read it? And he goes, no, because there's personal information on it. And it's pretty vague. I don't understand what it's all about, except I did ask him to give me the case numbers so I would be prepared to see you today. And I see it's from a charge in March of last year. That's all I know.
Okay, so you do have some information.
That's what I have right there. I just asked him to give me the case numbers off the upper right-hand corner of the paper.
Well, the case in the upper right-hand corner wouldn't clue you into the fact that this happened in March. So what
Yes,
information are you referencing that this happened in March?
That's the case. Numbers were from March. 2403 F600046.
I am referring to cause number 20D012501 F664. So that's the case that we're doing the initial hearing on. So the state of Indiana had filed that case back
I think he's around 29 years old.
on January 16, 2025. And in that case, they charged you with one count of invasion of privacy as a level 6 felony. It is alleged that on or about March 24, 2024, the County of Elkhart, State of Indiana, that you knowingly violated a no contact order issued as a condition of pretrial release or pretrial diversion by the Superior Court 1 of Elkhart County under cause number 20D012301. 2309 CM1725 to protect Mary Johnson, and that you had a prior unrelated conviction for invasion of privacy or stalking, said conviction having been entered on or about March 1st, 2022 in the Elkhart City Court under cause number 20H012112 CM5875, all of which is contrary to the form of Indiana Code 3546.1 15.1 subsections A5. Do you understand that that is the charge?
Well, you have to excuse me. That was all read a little too fast for me, but I have a gist of it, though I don't recall ever being charged with a stalking charge. Now,
Mr. Frost, hang on.
I kind of got hit on the side of the head with this morning. As I said to you, all I know is 2403 F600046. Now, 64, excuse me. Is that what we're talking about?
No.
Okay, so what am I talking about then?
What am I talking
Mr.
about?
Frost, I can't tell you what you're talking about. And
Well, I got hit this morning with a police officer coming into my cell block and just throwing this at me because he was in a hurry, and I'm going, here it is, the day of a trial, and now I'm getting a day of a hearing, and I'm getting hit with new charges. And all I saw was that it's from last year. And now, I'm a little confused on this whole thing right now. This is not what I was prepared to deal with today.
Mr. Frost, I told you at our last hearing that I would be filing the new charge.
Oh, you told me that, did you? I thought you threatened me with that, as you have been for months.
Okay, Mr. Frost.
No, come on.
Mr. Frost.
This guy is...
Mr. Frost, I'm regaining control of this hearing. Look, I have no idea why the state filed this charge, but it's certainly their prerogative if they believe that they can meet their burden of proof. I understand that you aren't expected to like it. I'm just trying to manage this. I'm trying to make sure that we get these cases moved as quickly. It's Mr. Frost, the cause number that we have been talking about for the last 10 to 15 minutes is cause number 20D012501 F664. It is a case that was just filed back on January 16th. However, the allegation is that the offense occurred back on March 24, 2024. It is not alleged that you were convicted of an act of stalking. The statutory language requires that the state of Indiana show that the elevation to a level 6 felony is because of a prior conviction for invasion of privacy or stalking. That's just the statutory language. So, Mr. Frost, I would suspect that you have been provided with the charging information. Otherwise, you wouldn't have known that the allegation was in March.
No.
Okay, Mr. Leong, Mr. Leong, it's the state's obligation to provide the charging information to Mr. Frost. Do you know if the charging information was provided to the representatives of the jail to in turn provide that to Mr. Frost?
I don't know for sure, Your Honor, but I can have one submitted just to be absolutely certain. I know we sent discovery earlier today pursuant to Local Rule 14, but I'll make sure that we send over a new charging information so that he has one for his records.
Okay, so Mr. Frost, I'm hearing that you will be provided with that, and the court will order the state of Indiana follow through with its obligation to provide that charging information to Mr. Frost. So Mr. Frost, I read to you the charging information, I believe word for word, as far as what it says. I'm not asking if you agree with the charge, but do you understand the charge that has been filed against you?
Yes, I do, but I also know I have not had any cooperation from this court since I've been here for months. It's a long time I've been here.
Mr. Frost, it's not my obligation to cooperate with you.
I know.
I don't know what it is that you think I need to cooperate with you on.
I mean, I've had 3 or 4 continuances by a...
I am using that all the time because lots of people feel like I need to cooperate with them when it's not my obligation to cooperate. Why do I have to cooperate? Give me a reason.
public defender who never even acknowledged me. I mean, come on. This has been a mess, and you've been angry about it also. I know you have been. Why is this continuing on with Mr. Frost? Forever and ever and ever. I've been incarcerated forever.
So, Mr. Frost, Mr.
Okay.
Frost,
Yes,
we have a trial on February 11th. So
Yes, we do.
I'm hoping to get some resolution for all of our sakes.
Now, did I actually hear the prosecutor say something about discovery? I've requested seeing discovery. I've got 3 weeks until a trial, and I haven't had a discussion with anybody.
Mr. Frost, I can't even get past this initial hearing that I'm trying to conduct, okay? Let's stay focused right now on the initial hearing. So let's contain that. Mr. Frost, I was going through the case that was just filed against you by the state of Indiana. I'm not involved in that. I don't know anything about that. I'm just trying to present you with the reality of that situation and meet my obligation to make sure that you understand your rights and also make sure that you understand the nature of the charge. I can't tell you anything beyond the facts that support this, and that's where Mr. Leong is saying that you will be provided with discovery in this newest case that will hopefully shed some light on more specifics of the allegations. We will come back in just a few moments regarding any type of discovery disputes that may exist in the other cases, but I need to stay focused on this case first, okay?
Right.
All right, so Mr. Frost, again, I'm not saying you have to agree with the allegations, but do you understand this newest case that has been filed against you, what the state has charged you with?
Why is it a felony?
Because of a prior conviction for invasion of privacy.
Oh, the one that I was granted an appeal on, that I'm considered innocent, correct?
No, it's out of Elkhart City Court, cause number 20H012112CM5875.
Out of city court. When was that, if I may ask, because I don't recall it?
March 1st, 2022. That's what the state alleges. I don't know anything about it, as it's not proper for me to investigate that.
Grodnick, right? Okay.
That would be Judge Grodnick, yes.
Oh, okay. Should be.
Mr. Frost, despite the fact that you disagree, I've been patient with you, but my patience is almost non-existent at this point in time. Any additional commentary or any interruptions beyond this point in time will be met with a potential contempt.
Contempt.
Yes, ma'am.
Mr. Leong, can you help the court understand why we have a 1-page charging document? Did something change under Indiana law that no longer requires a 2-page charging document when there's an enhancement?
No, Your Honor, that must be, that should be a 2-page charging document. I apologize.
Okay, so that is certainly a procedural defect that needs to be cured by the state of Indiana. I don't think that warrants not conducting the initial hearing. However, I want to be clear that should this matter go to trial, it will be a bifurcated trial, as there should be a page 2 that lists the prior conviction. So, Mr. Frost, Indiana law does require that the prior conviction be listed on a page 2, and that information cannot be put before the jury in the state's case in chief regarding the allegation that you violated in a no contact order or protective order on March 24th. So the The court will direct the state of Indiana within 7 days of today's date to cure that defect. All right, so Mr. Frost, I think I heard that you understand the charge. I did hear that you understand the rights. So I will enter a preliminary plea of not guilty on your behalf. That will become a formal plea of not guilty within 20 days of today's date. There are certain motions and defenses that must be raised in a time.
Okay. That part was all nothing. Now it gets better.
Manner. Otherwise, you run the risk of waiving or giving up any motions or defenses that you can file on your behalf. Mr. Frost, do you understand that certain affirmative defenses have to be filed in a timely manner? Also, there could be certain motions that have to be filed in a timely manner. And it is your obligation, if you choose to represent yourself, to figure out what those timelines are. Do you understand?
Yes.
Mr. Frost, taking into consideration the record that we've already had in the other causes of action where you have vehemently stated that you do not wish to have an attorney represent you, do you also wish to represent yourself in this newest case that was filed against you?
No, I'm requesting the public defender's office.
Mr. Frost, the court has already deemed that you qualify for the services of the public defender, and as such, I will appoint the office of the public defender to represent you in F664. I will give you the following dates. I will set an attorney conference on March 5, 2025 at 1 p.m., an omnibus date of March 10, 2025, and a change of plea hearing on April 21st, 2025 at 8:30 a.m. Mr. Frost, we will notify the public defender's office that they have been appointed to represent you in this cause of action, and somebody will be making contact with you at the jail in the near future. All right, so Mr. Frost, you have a trial coming up very soon, February 11th, for at least the two cases that went up to the Court of Appeals. So that's by agreement that those cases will be joined, and depending upon whether or not the state of Indiana files a motion for joinder in the other cases, it could also involve the other cases. Mr. Frost, I'm not sure that I've seen any type of motion to compel discovery, but I think I'm hearing from you now, maybe for the first time, that there's some discovery issue. Is that correct?
Yeah, I wrote a letter to you and requesting discovery as soon as possible. Yes, I have.
Mr. Frost, the court tends to be fairly lenient with letters. However, it's technically not a proper pleading. Letters that are filed with the court are not proper pleadings. They are ex parte communication to which the court technically cannot respond. Depending upon the form of that letter, the court can deem it to be a motion that would warrant some response from the court, but I do not respond to letters. I respond to motions, I respond to petitions.
Well, I have no way of doing that, ma'am, because I'm in a facility that has broken kiosks, no mail, no contact, continual lockdown.
This is news to me that you were prevented from filing any type of formal motion or petition.
All I have is an indigent envelope that I get occasionally that I write legal mail on, and I pass it through a correctional officer who supposedly gets it sent to you or to anyone else. We have no contact with the public defender's office on the kiosk machine. We have no contact with Rhonda. We're all just hung out to dry here on a regular basis. And now, if I'm sounding a little tart, is because I feel that way. Now I'm being told that any of the emotions and all the things that I'm going to have in my, as it says here, perils and pitfalls of representing myself.
As soon as I saw him, I knew he was a tart. I knew it.
It's going to get worse. So I know who I am. And I know I can talk to a jury because a lot of us are a little fed up with the way things are going. And so I'll deal with the perils and pitfalls. You just give me a jury and let me see some evidence and we'll see what's up. I'm angry. I'm tired. I've been incarcerated a long time on probational offenses. And it's been dropped into your lap, ma'am, and I'm sorry. I really am.
Mr. Frost.
And I hope I never have an outburst again. I hope I never have another outburst in your court. Please excuse my actions. Just a little fed up with being bullied by the prosecutor.
Mr. Frost, this court accepts handwritten motions and petitions all of the time. It needs to be in the proper form. So if you wish to file a motion or petition with the court, it's handwritten. As long as it's in the proper format, you may do that. And again, this is another reason why the court is concerned about you representing yourself at trial. Do you understand that?
What lawyers I've had in the past did absolutely nothing for me. They did absolutely nothing. I've had 2 trials now where I've represented myself. And
Mr. Frost, let's stay focused on my question. Again, I'm concerned that because you don't have access to some of the tools that you think that you need, that puts you at a disadvantage rather than using an attorney.
So a letter requesting isn't enough.
It is not.
Okay.
If the state of Indiana had filed a letter to me,
you know what?
Just Mr. Frost, stop. If the state of Indiana filed a letter saying, "Hi, Judge, how are you today? Here's my issue. Please and thanks." And I'm not trying to be demeaning, but if it was, and I'm just trying to be in the format, but it would be absolutely improper for me to respond to something like that. So again, you're being held to the standard of an attorney. So it's the same thing. Okay. So, Mr. Frost, are you certain, based upon the hearing that we've had today and this court's continuing expression of the perils and pitfalls of self-representation, that you do not want the court to appoint the Office of Public Defender or all of the other cases other than the case that we had the initial hearing on today?
After talking with you today and you being very direct with me, and I appreciate that, I don't want to go into that pitfall. Can I have the public defender's office back, and can I still have my trial, or is it going to be put off for another 18 months?
Well, I think that it would be unfair to the public defender's office to expect that they are going to be prepared to proceed on February 11th. So that is the risk here. So, Mr. Frost,
okay.
If you want the court to appoint the Office of the Public Defender, I will absolutely do that. But I want to be transparent with you that means that your trial will likely get continued.
Okay, so
She is about to chokeslam him right here with her words.
let's just assume this, and I'm not being arrogant with you, ma'am. I'm just angry. I have to ask you this. So if I went back to the public defender's office and then we start this roundabout again, he'll be able or she'll be able to get the evidence that I would request. I wrote in the letter to you that in the past with Superior Court number 5, that judge told me that I could only subpoena for information that was relevant if he viewed it as relevant to the case itself. And,
Mr. Frost.
Okay. I'm going to have the public defender's office because this is just going to get too difficult with you guys. Yeah, I'm going to have to step back from my representing myself and have a public pretender come in and help me. Can I still do that, ma'am?
Mr. Frost, that last comment concerns me about whether or not there is going to be a sufficient relationship with the public defender's office such that we're not going to just be back here in the same boat in another month. It offends me as a citizen of Elkhart County. It offends me as a judicial officer. Anytime that I hear people refer to the public defender's office as public pretender or not real attorneys or something derogatory like that, Mr. Frost, we can sit here and agree to disagree all day about whether or not you have been properly represented. I have no idea. I've not been involved in that. But what I will tell you, Mr. Frost, and this is...
I want to fight him now.
I think this might be the clinching decision here, or the fact that if I reappoint the Office of the Public Defender, your attorney is in charge of how the evidence is presented, any motions or petitions that are filed, Certainly, I am confident based upon my 20 plus years of having exposure to the public defender's office, both as a judicial officer, as a defense attorney, and as a former prosecuting attorney, that they will do everything possible to try to work with you, to try to present the information that you want presented, but within reason. They are not going to do things strategically that they think will be harmful to your case. They are also not going to do things that they don't believe are within the confines of the Indiana Rules of Evidence or any other legal authority in the state of Indiana. And I know that often that puts defendants at odds with their attorney when there's that disagreement. But I will be clear with you, Mr. Frost, that your attorney will be the one driving the bus, will be in charge of all of that. If you will agree to that, and if we don't have any further issues, then I would be willing to reappoint the Office of the Public Defender. But I also will be transparent about this. Mr. Frost, due to the history of this case, I know you need a resolution. That's clear, and I want to make sure that you get that resolution. Certainly, the state of Indiana needs a resolution, and I can assure everybody that the court needs a resolution here. We've got to get these cases resolved. So if you agree to the terms that the court just put before you, as far as trusting and letting your attorney handle your cases, then I will reappoint the Office of the Public Defender. But if things go sideways again, there is legal authority in the state of Indiana to say that you have waived that representation due to the lack of cooperation. Mr. Frost, do you understand the terms here?
Yes, I do, but one question. Thank you for explaining that to me. Very well, thank you. The problem is the communication system in this jail. I've had to have continuances because they couldn't even find me. I haven't gone anywhere. I'm right here. And you've had that
Were you under your cot? Maybe he was under his cot.
problem with this jail. I know you have. People not arriving, not being interviewed. I don't want to be hung out to dry in here. They don't even communicate through the kiosks to us. No one talks to us. We just sit here. We just wait. We just wait. No one talks to us. Rhonda doesn't come around. We can't send the messages to her on the kiosk. We can't send letters to her. The policemen, the COs, have been ordered by their officers not to deliver hand notes from inmates to her office. Direct order by the warden guys. I mean, this place works against us constantly.
Mr. Frost, I'm hearing your frustration, but what I'm trying to understand is what that might have to do with the court reappointing the Office of the Public Defender.
Well, they make an attempt to communicate with me. And can I have that much? That's all.
Like that's the expectation, Mr. Frost.
I am requesting to return to the public defender's office. I understand that it's going to stretch things out, but I'm so used to living like this now, ma'am. I'm here, and I'm going to ride it out to the end, all the way, and I'm going to behave, but I have to let you know how tiring this is. I'm not a youngster. I'm not a criminal. I'm an innocent man, and I've been held by the state of Indiana for something that was a minor offense.
Okay, so Mr. Frost, let's cut you off right there.
All 38 of them, minor.
All right.
Just before you incriminate yourself.
I'm tired.
Okay,
I'm
Mr. Leong.
tired.
Mr. Leong, is there anything that the state of Indiana would like to add at this point in time?
No, Your Honor.
Okay, so the court will reappoint the Office of the Public Defender for the other causes of action that are set for trial. And I will just wait and see what, if any, motions or petitions are filed by either the public defender or the state of Indiana. So at this point in time, Mr. Frost, unless or until I see a motion to continue, which I fully anticipate that I will, but unless or until I do, I will confirm your jury trial date of February 11, 2025 at 8:30 a.m. Do you understand that?
That will continue unless things change, correct?
Correct.
All right, thank you.
Mr. Leong, anything further that the state would like to address today?
No, Your Honor.
All right, so Mr. Frost, we will notify the public defender's office right away. And I know that they understand the need to get in touch with you and find out how you wish to proceed with these matters, and I trust that they will do that in the very near future.
Thank you.
All right, thank you. That concludes the proceedings.
Hey, well, at least at the end, she got him as no other judge that I've seen before. Get a lawyer. I've not seen that happen before. I was very, very proud of her. I don't know why he's wearing glasses with closed eyes. Hi, Stan. I don't know. Sometimes they're open, though. I can't get the trial on February 11th because there's no way it's going to happen. We both know as soon as we both, as in me and all of you, know that as soon as the public defender gets on, they're going to ask for a continuance. I'm going to be watching February 11th, but we all know that it's not going to happen. So we'll see how far they push it out. We'll see if I can get it. We'll see if he makes an ass out of himself with an attorney. Am I? Hello. You made it, and it's over. Oh, that's so rude. It's rude, but it's over. I can't stay awake any much longer. I can't. I gotta go to bed. Guys, I'm sorry Judge Fleischer is not streaming today. I'm sorry about the weather. Tomorrow's iffy. Tomorrow's iffy whether he's going to be streaming or not. Listen. Gosh. I have a clip for Micah's birthday that I want to play. But I might pull it out tomorrow if Judge Fleischer is not streaming. If he is streaming, then you guys need to go watch that. But I do have a special clip. Micah's birthday is in 2 days. And I have a Southern judge from Georgia we haven't seen before. That is amazing. He is so good. So I'm giving that to Micah for his birthday. So hopefully Judge streams tomorrow so I don't have to use it tomorrow. Or I'll find something else. Micah has a birthday. I mean, he just had one last year. So I don't know why we have to do it again this year. But he's greedy, so we're going to do it. We're going to give him a special Southern judge. Not Judge Reeves. He hasn't been in for a while. But he'll like it a lot. Guys, have a great day. Thank you so much for coming out. I really appreciate it. Bye, guys.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray,